Let's go across to the big story coming in from the top court today. You had the Supreme Court coming down heavily on the archaic sedition law. Now, Section 124A has been misused time and again by various governments, going right back to the British rule when freedom fighters were targeted for sedition, which is supposed to be any word, action or symbol or sign which can cause disaffection for the rulers of the day. The Supreme Court has been listening to a clutch of petitions and has now asked the central government why they want to carry on such an old colonial law. This is what the court had to say today. Abhimanyu has all the details.
The Supreme Court has taken strong exception over the misuse of the sedition law used to book people often found opposing various state governments and the union government. The court has asked the union government to file a reply and state if it's possible to do away with the law after 75 years of independence, likening the use of the sedition law to a carpenter cutting the entire forest with a saw given to him to chop a piece of wood. A three-judge bench led by CJI and Tamanna observed that the on-ground situation is concerning as Section 124A of the Indian Penal Code is being used by governments to book people speaking up against them, noting that the sedition law is a colonial era legislation used by the British to silence freedom fighters and was even used to book Mahatma Gandhi and Bal Gangadhar Tilak. The Apex Court pointed out that not only does the law have a very low conviction rate, but also has an enormous potential for misuse and acts as a serious threat for functioning of individuals and groups, citing Section 66A of the Information Technology Act, which was used to book people for airing their views before the provision was quashed by the Apex Court. The court asked the centre why the sedition law is still valid when the government has already repealed many stale and old laws.
All right, Sanjay Hegde, Senior Advocate of the Supreme Court of India, joining us for more on this. Sanjay, is there hope that we really may see at the very least a watered down version of the sedition law, considering what the government solicitors have said in court today, that the Supreme Court can lay down new provisions and they will be coming in with their petition as well on restricting perhaps the sedition law to places where there is security concerns, national security concerns and an attack on democratic institutions, etc. So are you hopeful of at least a watered down version?
Supreme Court had watered it down. They did it way back in 1962. They said you cannot use the law in this broad sense except when there is an incitement to violence and violence as a matter of fact ensues. So when they applied it in the 1990s, it was in the case of two Sikh gentlemen who, on the day that Indira Gandhi was assassinated, 31st October 1984, shouted slogans in Chandigarh near a petrol pump and said, Raj karega Khalsa and Hindu Raj nahi chalega and various other things like that. But there was no violence which ensued as a consequence of those slogans. The Supreme Court said that definitely was not sedition. Despite that, when you have an overbroad instrument, the police routinely misuse it. The Chief Justice was perfectly on the point when he said that it's like giving a carpenter a tool to cut down one piece of wood and they chop down the entire forest. You use sedition so indiscriminately against a butcher, baker, and candlestick maker. Cartoonists get within the ambit. News anchors get within the ambit. If you sort of anger a politician, you run the risk of some policeman saying, yes, we have filed a case of sedition. And do you know the maximum punishment? Life imprisonment. Why don't we first arrest you? You go, of course, the court will grant you bail after some time. And then maybe we will decide whether we want to try you or not. We will give the stage of cognizance will come much later. And after the trial, in about 95% of the cases, there is always an acquittal. My point is, why do you need an archaic, overbroad law, misused in most cases, which results in very few convictions, to ever exist on the statute book? It came about at a point of time when modern society had just emerged from the divine right of kings. Today, we have limited governments. We do not elect emperors. We do not consecrate kings. We have Pradhan Sevaks. We have leaders who are servants of the people. Now, if the people who are the masters say something is wrong with government, can the servant turn around and say, yes, I'm going to sentence you in for life imprisonment under sedition? Should that power exist?
Sanjay, I have a different question. Sanjay, if I may come in. So, even if we have, you're saying a watered down version already exists. Perhaps sedition as a law will be done away with completely. One can hope so. There are reams and reams written on this. So many experts have come and said that, this law really has no place in modern day India because we don't have rulers. We have elected representatives. But my question is about process as punishment. Whether it's the sedition law, whether it's, imagine 66A being used, which does not even exist, to book people, whether it's UAPA in some cases, as we have seen. The question is the process which takes so long that even if there is a conviction or an acquittal at the end of it, it doesn't matter because the person who's at the receiving end has already been punished, whether innocent or guilty.
Absolutely. That is because our court system is overcrowded and our investigating system actually revels in imposing punishment while all that they are authorized to do is to investigate a crime. So it is not necessary that in every crime there routinely has to be an arrest. But no, the investigating officer says that I cannot find out anything unless I have the man in my custody. And why do they need for custodial interrogation? That's all too apparent. The question is that if you make a harsh law and use it selectively against your opponents, then that is the textbook case of tyranny. So therefore, in a system of limited government, harsh laws, even if they remain on the statute book, must be invoked in the rarest of rare cases by written orders giving justifications as to why they were invoked and why arrests were mandated. And whoever writes that order must be able to take responsibility. If things go wrong, the person must be personally responsible. That never happens. There is no accountability for bad decisions. There is no accountability for tyranny.
So what do you think should be done in your view with the sedition law? Is scrapping it going to be enough? Is watering it down further going to be enough?
I do not think watering it down will succeed because the Supreme Court watered it down way back in 1962. And all that successive governments have done is to concentrate it even further, to pretend as if the watering down doesn't exist. So they get, to use a metaphor, they get power drunk on this section. I think the only way is to quit it cold turkey, absolutely scrap it. I believe the Congress party had in its manifesto also said that they would scrap the sedition law. And immediately there were people within the party who said, no, how can it be? It is so identified with national security. Please, if you want to ensure national security, have better policing. You have as many harsh laws as possible for violent cases. But for cases of cartoonists, cases of dissenters, cases of people who just have an opinion, if you are going to lock them up for life under sedition, then that is only perpetuating a police state. It is not establishing a democracy.
Yeah, and think of how outdated this law is, which started with the British times in an era where everyone is an opinion maker thanks to social media. There is no qualification to be an opinion maker. Everyone who has a point of view can put it out, is encouraged to. So can that scenario really coexist with a law like sedition is food for thought. Thank you so much, Sanjay, for joining us today on the show and talking about what could be the consequences of what we've seen. We'll take a very short break.